Good morning, everyone. Great turnout. Thank you so much for being here. My name is Paul Rose. I'm the Dean of Case Western Reserve University School of Law. It is our pleasure to welcome you to the 8th District Court of Appeals Advanced Appellate Advocacy Seminar. We are delighted to host this seminar again. This is our third year in a row in collaboration with the 8th District Court of Appeals. This annual event is offered at no charge for both in-person and virtual attendees, and it reflects our shared commitment to advancing the art of appellate advocacy. This seminar is a perfect complement to work that we do here in our curriculum at the School of Law. At Case Western, students are immersed in appellate litigation through courses like LEAP 3, which is our sort of third in our research and writing courses, where those students found advocacy skills in preparation for the Dean Dunmore Moot Court competition that we hold each spring. Our students, of course, also represent Case Western on the national stage, competing in prestigious moot court tournaments across the country. I was a transactional attorney in practice, but I was asked to be a moot court coach once upon a time. So this is definitely one of those things where those who can't do teach, because I never really was very good at it, but I did have success as a coach, and I really grew to appreciate how much work goes into doing it well. So I'm really grateful that our students are doing so well representing us on national stages. The appellate litigation clinic really serves as the capstone of the training that we provide here. It gives students hands-on experience as advocates. In the clinic, our students argue cases in appellate courts throughout Ohio and the 6th Circuit, including right here in the 8th District Court of Appeals. This semester alone, our clinic has participated in 4 appellate arguments, is managing 12 active appeals, and is awaiting decisions from the Supreme Court of Ohio on whether to accept 3 cases for review. Today's seminar agenda offers a wealth of opportunities to deepen your understanding of appellate advocacy and appellate practice. It begins with insights into effective appellate brief writing and oral advocacy led by experienced practitioners and judges. A panel discussion will follow on navigating key procedural rules and ethics in appellate practice, essential for both new and seasoned advocates. The seminar concludes with a thought-provoking session on emerging issues in appellate law with perspectives from members of the 8th District Bench and Bar. None of this would be possible, of course, without the cooperation and generosity of the 8th District Court of Appeals, the many judges, attorneys, and alumni who support our programs, and of course, all of you in this room. Your willingness to volunteer as moot court judges, coaches, mentors has been invaluable in preparing our students to excel as future appellate advocates. And of course, if you'd like to join our community of supporters, you can scan the QR code that's just outside by the coffee or at the registration table to be added to our judges list. So thank you again for joining us today and for your continued partnership. We look forward to a day of engaging discussions and valuable learning. It's now my pleasure to introduce Administrative Judge Kathleen Ann Keogh of the 8th District Court of Appeals.
Good morning, everyone. Thanks for coming. I want to just, on behalf of our court, thank all of you for your participation. It's nice to see some faces that we never get to see, because sometimes in the Court of Appeals, you're kind of cloistered and you don't get to see people. And I want to thank our staff for their hard work and preparation, in particular the Education Committee and all the presenters, and Case Western Reserve for making this possible. We really appreciate it. It's a great seminar. I don't know if it's your first time. It's really fantastic and great participation. And with that, I'd just like to introduce Judge Mary Jane Boyle, who is the chair of this seminar. Thank you.
Thank you, Judge. Welcome back. 3rd year, and it's growing. I'm excited about this year's program, and I'm just so thankful for the members of my court and the members of Case and the lawyers that have stepped up to participate and present advanced appellate seminar. I think last year I was mentioning to you, I really like to grow the appellate lawyers, community. We seem to me, to be overlooked a lot. We provide this program because a few years ago, well, maybe a decade now, I don't know, they came up, the Ohio State Bar Association in the state of Ohio offers appellate specialization certificates, and you need advanced appellate CLEs. Also, to be on appellate assignment lists to do criminal appellate assignments, you also need a lot of appellate CLEs. And when we heard from the lawyers that there wasn't enough advanced appellate CLEs being given opportunities for you all, our judicial attorneys came to us and said, we need to do this for the community. And so that's why we bring this program to you today. Our first group I'd like to introduce is the program is entitled Missed Persuasive Opportunities. And you're going to hear from Tony Farkas, Dave Parcham, who are staff attorneys at the 8th District Court of Appeals. And then you're going to hear from Melissa Greist, an adjunct professor at case law, who used to also work at the 8th District Court of Appeals. So they regularly review the transcripts, the evidence, the records, participate with helping the judges put on their decision-making, their opinions. And so they wanted to bring to you what they see from behind the scenes on some of the persuasive opportunities as appellate practitioners that you may be missing. Instead of going through all their bios, you may come on up, you guys. Instead of going through all their bios, you can read it in the electronic format the materials are included in. And we're going to move rapidly from group to group. So I hope you enjoy this program and you learn lots. With that, Tony, Dave, and Melissa. There's some in the back end. Thank you.
Good morning. I'm Tony Farkas, and as Judge Boyle said, I'm here with Melissa Greist and Dave Parcham, and we're hoping to provide some suggestions on ways to make the most of your persuasive opportunities in appellate briefs, oral argument, and throughout the appellate process in the Court of Appeals. In preparing for the presentation here today, I sort of canvassed our court a little bit and asked for views on what can detract from the effectiveness of an appellate brief or oral argument, or that can just make the appellate process a little more difficult. And so I'm going to try and incorporate some of that feedback here today. In my part of the presentation, I'm going to try and focus on how persuasiveness can be impacted by practical considerations in the way the court operates and the requirements of the appellate local rules. Melissa, a professor in appellate practice, will provide tips regarding legal writing techniques to maximize the persuasiveness of your written arguments. And then Dave has been with the court for almost 34 years.
34 years.
And he's probably seen it all. We'll probably do a little bit both. First, we're going to start with appellate briefs. As I'm sure you all know, under the Ohio appellate rules, briefs filed in the Court of Appeals must have 8 components: the table of contents, the table of the cases, a statement of the assignments of error, a statement of the issue presented for review, a statement of the case, a statement of facts, and an argument containing an argument and then a conclusion. I'm not going to go through all of that in detail, but one thing I learned fairly quickly on when working for the 8th District is that different judges take different approaches to reviewing an appeal, particularly with regard to what they review first. Some judges review the assignments of error first, some review the statements of issues, some review the table of contents, some review the order or judgment appeal form, and some review the reply brief. Because you don't know what the judges assigned to your case are going to do, you really want to make the most of each of the elements of your appellate brief. Today, we're really going to focus on the heart of the appellate brief in our discussions today. And I'm going to begin with the statement of the assignments of error presented for review. What I consider to be the third most important part of your appeal. In prior CLE seminars that we've covered here with the 8th district. We've covered what is in my view the first and second most important parts of your appeal. One, a timely filed notice of appeal, and two, the record on appeal. If you don't have those two items, or you don't have what you need for those two items in your appeal, persuasiveness really doesn't matter. So why do I call the assignments of error the third most important part of your appeal? It has to do with Appellate Rule 12A1. Appellate Rule 12A1 tells the Court of Appeals what it must do in an appeal. On an undismissed appeal, the Court of Appeals shall review, affirm, modify, or reverse the judgment or final order appealed, determine the appeal on its merits, on the assignments of error, the record, and the oral argument if there is one. And then 3, unless an assignment of error is made moot by a ruling on another assignment of error, decide each assignment of error and give reasons for its decision in writing. So when getting relief from the Court of Appeals, it's really all about the assignments of error. The Court of Appeals is required to decide and issue a written ruling on each assignment of error that's raised and briefed. It's not required to address or resolve every argument or issue raised in the appellate brief. And I'm sorry, some of these are a little small, but I believe you'll get our PowerPoint slides, so you could be able to see some of the sites or whatever that's in here that might be a little small. Here, you should be able to get them in a written format. So what's an assignment of error? Common definitions are a concise statement of the question to be reviewed, a short description of a mistake alleged to have been made by the trial court. Assignments of error should designate specific rulings that the appellate challenges on appeal. These are different definitions that have been provided. It's important to note that assignments of error are not propositions of law, like you might see in a memorandum in support of jurisdiction if you have a Supreme Court. They're not a statement of a rule of law that the parties argue should be applied to the facts. They really are a statement identifying a mistake allegedly made by the trial court. There are 2 types of assignments of error. One, general assignments of error, and issue-specific assignments of error. A general assignment of error is a broad statement of a mistake made by the lower court without providing specific details about the error. An issue, something like that might be, for example, a general assignment of error might be the trial court erred in granting the appellee's motion for summary judgment. An issue-specific assignment of error identifies the exact problem with the trial court's decision. Maybe along the same lines, something like the trial court erred in granting appellee's motion for summary judgment because there were genuine issues of material facts with regard to whether appellee breached the contract with appellant. You really want to make sure and review the local rules. Some local rules have specific rules regarding assignments of error, and they require specific assignments of error as opposed to general assignments of error. One thing I've learned is that sometimes there are local rules about things you wouldn't expect to be local rules about. So reviewing the local rules at the beginning of your brief writing process or your appeal process and the end of your brief writing process or oral argument is an important consideration. Here I cited the 3rd district's local rule that says assignments of error to the degree reasonably possible should not be general in terms, but should be specifically applied to the error claimed. So just a word of caution. Look at the local rules. Assignments of error really set the parameters of what the Court of Appeals decides on appeal. So how you frame your assignment of error matters. There's a risk of being too specific or not sufficiently comprehensive with your assignment of error. Where an issue is raised in an appellate brief exceeds the parameters of an assignment of error, the appellate court may refuse to consider it. For example, I cite this Bradley case. In that case, the assignment of error was that the trial court had waited 37 days to issue findings of fact and conclusions of law after trial. The party in the brief made an argument that it was prejudiced because it was not served with the proposed findings of fact and conclusions of law, and the court said, well, that's outside the scope of your assignment of error. In another case, I didn't cite here, but it's State versus Zanny. A separation of powers argument was raised sort of as a sub-argument under an assignment of error that involved due process and the confrontation clause. And again, the court said, that was outside the scope of the assignment of error. There should have been a separate assignment of error with regard to that. There's also a risk of being too general or imprecise with your assignment of errors. You really do have to make sure that your assignment of error identifies the particular action or determination by the trial court that you're claiming was a mistake. There's no catch-alls. You can't say something like, the trial court's judgment was contrary to law. There may be some strategy involved in framing your assignments of error, sort of harkening back to the notion that the appellate court is required to resolve assignments of error and not arguments or issues. So if you want to increase the likelihood that the Court of Appeals actually decides a particular issue that you are interested in, you might think about that in framing your assignment of error. But otherwise, unless issue-specific assignments of errors are required under the local rules, you can use general assignments of error and then use the statement of issues presented to really sort of flesh out what the errors are. And Dave's going to talk a little bit more about that in a few minutes. The bottom line with all this is really think about what you're doing with your assignments of error. I think a lot of times people just sort of, slap them down to comply with the rules, but they can be very, very important in your appeal. So now I'm going to talk about sort of the technical side of assignments of errors. To comply with the appellate rules and be considered by the Court of Appeals, each assignment of error must be raised and argued in the opening brief. You might think that this is sort of, common sense, but you'd be surprised. You can't incorporate by reference arguments made in other briefs that were filed below. It's not uncommon for us to get briefs in which somebody says, I hereby incorporate the reference by reference the arguments I made on page 18 of this opposition, for summary judgment I filed in the trial court. We get that, not infrequently. And you can't do that. That doesn't comply with Appellate Rule 16. Arguments and footnotes generally aren't enough. The argument should be in the main body of the brief. And unless leave's granted, you can't raise new assignments of error in your reply, and you can't raise new assignments of error in oral argument. Each assignment of error must also be argued separately. Although the Court of Appeals has the option to address 2 or more assignments of error at once, the parties do not. And you can't simply incorporate by reference arguments made in support of one assignment of error and ask that it be applied to another assignment of error. Sometimes we see that in cases where sufficiency and manifest weight of the evidence arguments are made. Sometimes we'll have a party that will say, for the same reasons I asserted that the evidence was insufficient, it was against the manifest weight of the evidence. And really you need to have separate arguments for each assignment of error for that. Not to mention that they have different standard of review, so it might be the reason why we would also want to have a different argument. Assignments of error must also be accompanied by citations for the record, be supported by legal authority, and is supported by contentions and reasons. Argument support be supported by argument with contentions and reasons. You have to have a meaningful analysis. Blanket or conclusory statements are insufficient, and the court's not going to make arguments for you. Failing to comply with any one of these requirements is grounds for the Court of Appeals to disregard your assignment of error without addressing the merits. And the source of what allows the court to do that is Appellate Rule 12A2. And courts do this regularly. In the Court of Appeals, if something is not argued separately, if it is not supported by sufficient argument, it's a reason oftentimes courts will disregard an assignment of error. Or they might say, even if we were to consider this assignment of error and go from there. But courts will sometimes, in the interest of justice, consider improperly argued assignments of error. We don't want to count on that. I'm now going to turn it over to Dave, who's going to discuss persuasive opportunities in connection with your statement of the issues presented for review.
As a staff attorney with the 8th District Court of Appeals for over 34 years, one of our primary responsibilities is to review the briefs coming before the court to ensure their compliance with the rules, specifically Appellate Rule 16, which specifies the various components of a brief. One of those components is the statement of issues presented. And generally speaking, all too often, the attorneys and pro se litigants take their assignment of error, turn it into a question, and leave it at that. The assignment of error is the court erred in granting summary judgment. The issue presented, did the trial court err in granting the motion for summary judgment? And this is done with mind-numbing regularity. In this, you are missing a persuasive opportunity to convince the court. If you can frame this case through the issue presented the way you think this case should go, you take a big step toward winning your case. Now, there are various ways of doing this. I like the quick punch to the gut and, quick, concise statement of the issue presented. Like, a breach of contract case. You say, this case is a case about waiver, or this case is a case about the statute of limitations. E.g., the guy says, he's agreed to sell me his autograph book, and I gave him the money for it, he never gave it to me. The reply is, this case about the statute of limitations. That transaction happened 16 years ago. It's beyond the statute of limitations. That's how you can frame your case. Now, hopefully, you'll be able to maybe invoke some great principles of justice and law in trying to do this. A good example is the case of State Department against Munez from the U.S. Supreme Court case. In this case, Marcy Munez married Louis, who is a citizen of El Salvador. They wanted to live in the United States. However, United States law requires a person, a foreign national, to go back to their home country and apply for the visa there. Louis goes back. Louis is denied his visa because there was evidence he was engaged in illegal activity. So his wife, Marcy, starts the appeal, goes up to the U.S. Supreme Court, and she and Justice Sotomayor said this case is about the right to marriage and the right to live where you want, and thereby invoking the transcending principles of marriage and personal liberty. In the decisive opinion, Judge Barrett says, no, that's not what this case is about. This case is whether the judiciary has any authority to review visa determinations made by the State Department. That's what this case is about, and she thereby invokes the constitutional principles of separation of powers. Now, that's not the only way you can do this. There's another way of doing that. Let's see if I can bring it up. What I call what's often called the syllogism. Now, in certain districts, this is required. I believe it's required in the 3rd district and the 9th district. And in this one, you state a principle of law. You have a couple of minor premises dealing with the issues of facts in the case, and then you have your conclusion, a question like a yes or no question stating the issue of the case. And the classic example everybody gives is the premise is the excited utterance exception allows a declarant statement to be admitted if it is made under the stress of a startling event. In this case, the Vince victim calls the 911. Policeman shows up 30 minutes later, and Vince tells him, Dr. hit me with a baseball bat. And the issue then becomes, is this an excited utterance so that the policeman's declaration is admissible hearsay? That's the issue. Take a couple of more cases. That's a case involving burglary. The elements for burglary is trespass into an occupied structure by force, stealth, or deception to commit a felony. One of the cases before the court, so that would be your premise. The elements of burglary. The specific minor premise is the testimony of the victim. Vince comes up and he says, I was carrying my groceries into the building, and these 3 guys came out and with guns and robbed me. The issue is that sufficient evidence to prove by reasonable doubt that there was trespass into an occupied structure to complete the elements of burglary. Or another one involving burglary. Trespass would be by force. Trespass, you can have consent to enter a building, and that's privilege to enter the occupied structure, but that can be revoked and it can be terminated by a violent act. In a very recent case before the court, Vince owed his drug dealer $1,500. He didn't have the money to pay for it. And consequently, both the drug dealer and Vince went back to Vince's apartment with the full knowledge that the drug dealer is going to beat him up because he can't pay. The question, the issue then is, does the full consent to this violent act constitute, full privilege, nullifying the element of trespass? That's how you could frame these issues. Once again, you're missing an opportunity to frame the case if you just turn your questions around. I will finally leave you with the all-important case of North Coast Cookies against Sweet Temptations, Inc. A very memorable case name, in which the 8th District Court gives the best common law definitions of an assignment of error and issues presented. Thank you.
Okay, so you've framed your assignments of error, you have your persuasive issue statements. It's time to turn now to the argument section of your brief. So I'm going to touch on 4 opportunities for you to be persuasive in your argument section. Incorporate the standard of review, use argumentative point headings, exploit positions of emphasis, and avoid over-advocating. Okay, standard of review. So Mr. Regas later this morning is going to do a deep dive on appellate standards of review in Ohio. I'm not going to talk substantively about them to step on that presentation, but I propose that you do not need a separate heading and boilerplate section about the standard of review unless local rules require it. If your standard of review is not in dispute, instead of taking half a page to tell the appellate court that summary judgment motions are reviewed de novo, right? Use a sentence or 2, cite a case, and use the rest of the space that you would have spent doing that more effectively. Once you have your standard of review, you state it, you then want to take the next step and actually incorporate it into your argument. So following along with the summary judgment example, it's a summary judgment, it's reviewed de novo, the appellate court gives no discretion to the trial court's reasoning. So in addition to including in your brief, why the trial court's reasoning was incorrect or correct, you also need to establish why you win, right? If we're talking about a negligence case and maybe the trial court found there was no duty of care, and so there was no need to address the other issues. With the de novo review, yes, you have to talk about the duty of care, but then you also need to show why you win or the other side doesn't, all right, on the other elements, right? Breach, causation, damages. So incorporating the standard of review into the structure of your actual argument is really important. One way to then communicate that in your brief is to incorporate the standard of review language into your point headings, which brings me to strategy number 2. What are argumentative point headings? Not surprisingly, they are argumentative sentences that make a point, right? You want to accomplish a couple different things with these point headings, and it helps to think about 3 different categories of people. So you want to think about your reader, right? This is someone, a judge or judicial attorney who is going to pick up your brief for the first time, read it cover to cover really closely, right? You want them to persuade it from the very first page, whether they start at the table of contents or different, whatever part of the brief. And so what's the first page or maybe second page of your document once you get past the cover sheet? It's your table of contents, right? And your table of contents is comprised of your argument headings, right? That are the headings that you use throughout your argument section feed into the table of contents. So use those headings and that space right on the first page of your brief to concisely say what your best arguments are and how they relate to each other. As a more practical matter in your argument section, including these subheadings and argumentative point headings helps break your argument into chunks that are easier for the reader to digest. Everyone reading these briefs are also reading a lot of other briefs, right? And just generally reading, and it's tiring and it's hard to get through all of those briefs. So the easier you can make it for the reader, the more persuasive your words are actually going to be. Second, you want to think of someone using your brief, right? This could be the same reader maybe a couple of days later, right? The judge, judicial attorney is, remember you made a point about something, but where is it? I need to find it. Craft your argument heading so that it's easy for someone using your brief to find what it is that you're arguing. And then lastly, think about yourself as the writer. Taking some time to draft these argumentative point headings helps you really grapple with what your arguments are and how to succinctly state them and organize your points. So at a basic level, to make argumentative point headings, you should be using complete sentences. Okay, that's easy enough. The trickier part comes in to figuring out how to balance including enough specificity to make the headings concrete without making them so long that the reader and the user are just going to skip them and not read them all together, right? So your heading is too long if it goes more than 2 or 3 lines. If you use all caps for this, right, no one's going to read that 2 or 3 lines, so consider not using all caps. But on the flip side, your headings are too vague. If you could take the same heading from another brief and copy paste it into a brief for a different case, okay, right, that's not specific to your case. Or if your opponent could take that heading and put it in their brief, right, then it's not persuasive enough to your side of the argument. So if you're not sure how to go about crafting these, you can start with this default formula. So start with a conclusion that you want the court to accept or an action that you want the court to take, and then include the reason why the court should accept that conclusion or take that action. If you have just one reason, you can do that in one single heading, right? You don't necessarily need any subsections. But if you have a lot of different reasons why the court should accept that conclusion or take that action, you can include the why as separately as subheadings underneath the broader heading. So for example, the writer here has 3 reasons to support their argument about why the court should hold a specific thing about this 4th Amendment exception. Rather than trying to put all 3 of these reasons into one long heading that would be like 5 or 6 lines that no one's going to read, they break that up into 3. Each reason why is its own subheading that more clearly communicates what the reader is trying to say. It also has the added benefit then in your argument section of breaking up these reasons why into easily digestible chunks. One of the reasons why you want to break up your argument into easily digestible chunks, other than the fact that it is easily digestible for the reader, is to exploit positions of emphasis in the brief. So this is strategy number 3. The general principle here is that readers pay more attention and remember things better when they come at the beginning or the end of a mental or physical break. So strategically, you want to craft your argument section to create more beginnings and more endings. So one of the ways to do this is to use these argumentative point headings. The heading itself is a point of emphasis, right? It stands alone on a page. It's usually bold, right? It's you can't get a better point of emphasis than that. And then you can also create more positions of emphasis under a subheading by breaking up paragraphs, right? You're creating more beginnings of paragraphs and endings of paragraphs. You also can use a short 1 or 2 sentence paragraph, right? I know that might startle some of you. You can have a 1-sentence paragraph, right? Maybe when you are learning general rules of English, right, paragraphs have to be 4 or 5 sentences long. well, now we're in an advanced appellate seminar, right? You can do it, a couple of times, right? Don't overdo it, that might just get annoying, but that can be a way to really create points of emphasis and more beginnings and afters, right, on either end of it. So once you have your positions of emphasis, you want to put your best points in those positions. So, at a global level, put your strongest issues first, or your strongest within each issue, put your strongest arguments first. Unless, of course, you have a threshold issue like jurisdiction or standing. Of course, then you maybe want to flip that around. Like, for example, the problem we're working on in class right now has a jurisdictional issue. And our students briefs are due today, and we've been talking a lot about, okay, do I put that issue first because it's threshold, or do I move it second because maybe the merits argument is stronger, right? So if you have something like that, of course, disregard what I'm saying. But within each issue, then use your paragraphs to use to really emphasize the points you want to make. So short, specific topic sentences to take advantage of that position of emphasis at the beginning of a paragraph. In your topic sentence, state your conclusion as if it were the truth, right? Don't waste that precious space at the beginning of a section by saying the next issue is, right? Or the appellant argues, right? Just say what the issue is, right? Get rid of that space and really exploit that position in the in that prime spot in your brief. And oh, yes, sorry, there was an animation there I forgot about. Don't do that, right? Okay. Finally, the last strategy: avoid over-advocating. Don't attack opposing counsel, right? This can be really tempting, especially when they're just wrong, right? So, you're going to see sentences like this a lot. Maybe not a lot, hopefully not a lot, especially after today, right? But in his opening brief, Jones lied by saying his appeal was untimely, or appellant is trying to distract the court, or strategically misrepresents this case, right? Now that might be true, but you don't want to be the one to put your credibility on the line to make that assertion. So instead you want to just rephrase the wording a little bit to get rid of explicitly attacking the other side, and implying what their intent is. So I don't know, do we have maybe a minute? Does anyone want to guess or propose how you would maybe rephrase that first one about the Jones lied by saying his appeal was untimely?
How about just saying, despite the appellant's protestations, this appeal is untimely?
Perfect. We don't talk at all about whether he was doing that strategically or not. Okay, for the sake of time, I won't go through the other ones. Okay, another way to avoid over-advocating, right? Don't lie to the court. I think we got a question about that last time the 8th district up here was a pet peeve, or just one of the judges was saying, well, you're just misrepresenting the record, right? Or what a case says. It's hard to lose your credibility faster than that. So stick with what you can support in the record. And then more at the sentence level, watch out for adjectives and adverbs. That's usually a sign that you're kind of slipping into over-advocating, making generalizations that are not, or conclusions that are not persuasive. So instead, you want to use words that signal you're giving more concrete, specific information. So, if you have to say clearly this is the right way to go, if you have to say it's clear, it's not clear, right? Use stronger nouns, use stronger verbs, use more specific language, right? Instead, look for words that you can add into your sentence, like precisely or specifically, and then add those details to show what specifically or precisely it is you're talking about.
I would just remind everybody what Stephen King said on writing: the adverb is not your friend.
Yes. And then finally, with the over-advocating, keep your reputation in mind, right? While maybe over-advocating at a specific level, attacking opposing counsel, lying about a case, sure, it'll hurt your credibility in that particular argument. But Cleveland's a small legal community, right? If you get in the habit of doing this, this will build your reputation of becoming maybe untrustworthy or not a good advocate. And I don't think there is a more efficient way to miss all of your persuasive opportunities for all of your cases. I'm going to turn it back over now to Tony.
Technical requirements. I'm not gonna spend a lot of time on this, but I would be remiss if I didn't at least mention the fact that complying with the technical requirements are really an important part of the brief when you file with Court of Appeals. They're set forth in Appellate Rule 19 and the local rules. In particular, take care to avoid including unauthorized personal and private information in your appellate brief. That's an issue we see come up a lot, you know, the names of minors, victims of sexual assaults, and there's some other personal and private information that's specified in the local rule. Technical requirements really do matter. If your brief doesn't comply with all requirements, your brief could be stricken, your appeal could be dismissed, or you could receive a non-compliant order. If your brief does contain the names of minors or victims of sexual assault in violation of the local rules, it will be stricken, but you'll usually be given an opportunity to file an amended brief that complies with the rule. If your brief substantially complies with the technical requirements of the rules, but it's non-compliant in one or two minor respects, you know, footnote type's too small, the margins are too narrow, but you're not doing it in a way to evade the page limitations, you may be issued a non-compliance order, something like this one. You may not realize this, but the 8th District actually tracks the issuance of these non-compliance orders. So if an attorney is repeatedly non-compliant, despite prior warnings, it may increase the likelihood that a more severe sanction will be imposed for future non-compliance. So nothing's more of a mispersuasive opportunity than having your brief stricken or your appeal dismissed. So you just want to be careful about that.
If I may interject, the court is really trying to protect the children, and if there is a minor in any way associated with your case, please make sure there is no way this minor is identified, even if you use initials for the minor, but then use the minor's last name later in the brief, so that you can put together this child, you know, is fungible. The court will strike that because that effectively identifies a minor. We're really trying to protect the kids.
Before discussing oral argument, I sort of want to take a little detour and raise an area you might not think about when considering persuasive opportunities in connection with an appeal. Mediation. As you may know, the 8th District has a really robust, successful mediation program. Nothing that's said in mediation ever makes its way to a panel, but preparing for the mediation, preparing a mediation statement, and participating in mediation may help you focus on what the real determinant issues are in your appeal and where the strengths and weaknesses lie. There's always value in determining your own fate. Successful mediation can avoid the need for taking advantage of some of the other persuasive opportunities we've mentioned up here. And you can request mediation at any stage in the process. So I just wanted to give a shout out to Newton, who's in the back, who is our court mediator, and encourage you to take advantage of that mediation opportunity. Now turning to oral argument. One of the greatest persuasive opportunities can be effective use of oral argument. Whenever I attend an appellate judges panel, the question is almost always asked of the judges, how frequently has oral argument changed your mind in a case? In my opinion, that's a very narrow view of the value of oral argument. Personally, if you have something that's worth saying, and if your client is willing to pay for it, for you to participate in oral argument, I would never waive oral argument. Oral argument can provide an opportunity to address potential issues with the record that you may not have realized have come up during the course of an appeal. It can allow you to reframe the issue in a different way than was presented in the brief. You can answer questions from the court. You can address issues that the court deems significant that may not have been addressed in the parties' briefs. It really just gives you an opportunity to sort of seal things up in connection with the appeal. If you didn't file the last brief, it's the only opportunity you have to respond to that brief. And clarification of issues during oral argument can lead to better opinions down the road. It's also not just an opportunity for you to persuade the panel, but maybe an opportunity for one judge on the panel to persuade another judge on the panel based on the questions asked by the judges. pulling back the curtain a little bit, with regard to how things work in the 8th district, as you may know, in the 8th district, 3 judge panels assigned with 1 judge assigned as the writing judge, approximately 6 weeks before oral argument is scheduled. If no oral argument is scheduled or requested, then a date will be assigned when the case is ready for consideration, which is usually the date the oral argument would have been scheduled had it been requested. Everybody gets a notice when that happens. I'm sure you've seen those notices. In the 8th district, memoranda or draft opinions are not generally circulated among the panel members before oral argument. The judges do not generally conference about a case before oral argument. They usually conference about cases after oral arguments are completed for that day. So if an oral argument is held, what's said during that oral argument will really be fresh in the judge's mind when they conference about a case. It may be the last thing that the judges actually think about the case before conferencing. So that's really something to think about when you're deciding whether to waive oral argument. Just as a reminder, you now have to request oral argument. If you request it and decide you don't want it, file a motion to waive it. If you are an appellee and don't file an appellate brief, you will generally not be permitted to participate in oral argument. Almost universally, the judges dislike motions for continuance of oral argument. The judges have busy schedules. The panels change from week to week, so it may be a while before the panel members sit together. There's limited courtroom space. If you think you need a continuance of oral argument, maybe consider a Zoom argument. They've really gotten much better now that we've gotten sort of the system down. Or better yet, be proactive. If you know that you are going to be unavailable for a period of time due to a long planned vacation, a trial, a planned medical procedure, file a notice of your unavailability with our court administrator court assignment commissioner as set forth in local rule 21D. And if it's reasonable, the court usually honors those requests. So you can avoid having oral arguments scheduled at a time that's not convenient for you for legitimate reasons. If you do request oral argument, be prepared and have something to say. All right, district judges come to oral argument prepared. They've read the briefs, they've reviewed the transcripts, they've read the cases. As one judge told me, don't spend your 15 minutes regurgitating the facts of the case. We know them. Choose 1 or 2 key issues to highlight why you should win and focus on those. Be prepared for questions. Our judges like to ask lots of questions. Know exactly which relief you want the court to give you. And if there are multiple potential ways to resolve an appeal, know what relief you want in each scenario. And know what relief you don't want and why. I mean, in certain cases, the relief is clear, this is an issue, but when there is an issue, it really is sometimes surprising that the court will ask a party, what exactly do you want? And it's surprising the number of times that somebody may not know the answer to the question or not be able to articulate it specifically. And if you're the appellee, be prepared for the question where they may ask you is, the appellant says they should get this relief, do you agree? Be prepared for that question. What is not a mispersuasive opportunity? Filing an application for a reconsideration or en banc consideration in the usual case. It's not a second bite at the apple. The standard for reconsideration isn't actually set forth in the rules, but it is pretty clearly established in the case law by now. An application for reconsideration is appropriate where there's an obvious error in the decision or an issue that was not considered at all or not fully considered by the court when it should have been. It's not for use when a party simply disagrees with the logic or conclusions of the court. It's not a means to raise new arguments or issues, and it's not a prerequisite to further appeal. Likewise, en banc consideration is not, in the usual case, a mispersuasive opportunity. En banc review is intended for the rare case in which a court like ours, where there are many judges, the decision of one panel conflicts with the decision of another. And in the 8th district, there are very specific requirements for en banc applications that are set forth in our local rules, including the 1-paragraph statement of the dispositive point of law on which the 2 decisions conflict, and the identification of the specific paragraphs in each of those opinions of the conflict. Any application for en banc consideration that does not comply with the requirements of the rules may be summarily denied. You do need to remember that if you're filing both en banc and reconsideration, they have to be in one application. And I've been asked to remind everyone that local rule 23A in terms of filing of frivolous motions does apply to applications for reconsideration and en banc consideration. So. Now, at the outset of this presentation, I told you that when I was preparing for this presentation, I sort of canvassed the court and asked for their feedback regarding what practices detract from the effectiveness of an appellate brief or oral argument, or that can just make the appellate process more difficult. I wasn't entirely honest with that. What I really did was ask the court for their pet peeves. And so we don't have a lot of time, but you will get all these in your materials. And
But I think we might actually be out of time.
oh, we're out of time?
We gotta
Okay.
direct you to the materials.
Okay, so I will have to direct you to the materials, but there's a number of pet peeves here. I'm sorry we ran out of time to include them, but they'll be in the material. So listen, just some of the things that the judges and other members of the court find can undermine your effectiveness with your appeal.